We'd like to acknowledge the death of 3 farm workers who unfortunately died as a result of being in unsafe and dangerous working conditions. And I would just like to mention their names: Bonifacio Eugenio Romero, who's 31, Rogelio Munez Santos, 24, and Juan Lopez Shapiro, who was 55. Apologies for the mispronunciation. So just before going further, we just wanted to acknowledge their contributions to this program and to just continue to contribute towards the work that was started by great individuals before us. And as I mentioned, there have been a lot of abuses and problems with the migrant worker program, and a lot of it is due to the unjust immigration system that we have. And so today we'll be exploring some of the ways in which the system works and how it continues to be a struggle for workers and advocates and allies who are trying to navigate the process. So as you can see on your screen, we just have a brief timeline of the Temporary Foreign Worker Program as it relates to migrant farm workers. The SOP program, which was created in 1996, is the Seasonal Agricultural Worker Program, which was created in response to Canada's domestic labor shortage in the agricultural sector. It essentially permits workers from Mexico and participating Caribbean countries to work in primary agriculture in Canada for a maximum of 8 months each year between January 1st and December 15th. And the duration is supposed to be a minimum of 6 weeks to a maximum of 8 months. But of course, because of COVID, that timeline has also shifted. And then we also have the agricultural stream, which was formerly the NOC C&D pilot programs. And the agricultural stream program is essentially where employers can hire temporary foreign workers from any country for a maximum of 24 months. Similar to the SOP program, employers have to conduct recruitment efforts to hire workers, but before they can do so, they have to see if there are Canadian workers who are able to do the job. And then as of right now, we do have 4 streams under which the temporary foreign worker program occurs, and those are the SOP program, which is the Seasonal Agricultural Work Program, the agricultural stream, the stream for high wage positions, and the stream for low wage positions, and we will be going deeper into that. So the IRPA is the central piece of legislation which governs the SOP program and the Temporary Foreign Worker Program, and it is the Immigration, Refugee, and Protection Act, which has many objectives. But the section that pertains to migrant workers specifically is essentially to facilitate the entry of visitors, students, and temporary workers for the purposes of trade, commerce, tourism, and cultural, educational, and scientific activities. It is the authorizing section, which makes it
Pardon?
legal for migrant workers to enter and
No.
become employed in Canada for a brief period of time. And then next, we just have a visual over here for you, just describing the pathways to permanent residency or lack thereof, focusing on migrant workers. So the NOC program system is essentially ways in which the occupations by skill level and skill type are classified in Canada. It's a tool that is used by Immigration, Refugee, and Citizenship Canada to identify skill shortages in the job market and to standardize educational and occupational requirements. As you can see over here, the high skill categories are the A, B, and the O. So those are the high skill categories where the requirement is usually a university education or a college education. However, migrant farm workers fall under the C and D skill level designation that we see at the bottom there, which requires completion of like secondary school and a short work demonstration or on the job training. As you can see here, the high skill categories, there is a pathway to permanent residency, but with the low skilled workers who are in the C and D NOC categories, there is not as of yet a pathway for permanent residency. And this is where the SOP program, the agricultural stream, as well as other low skilled streams come under, with limited exceptions with regards to the live-in caregivers program. So we are going to be discussing the processes through which migrant farm workers come to Canada and the processes that they have to go through. We will go going through the employer-specific work permit specifically, the temporary resident visa, and the open work permit for vulnerable workers. So the process starts off with an LMIA, which is the Labor Market Impact Assessment. And essentially, what that is the Canadian government requires employers to first advertise all employment opportunities for seasonal agriculture work to qualified Canadian citizens and permanent residents for a minimum of 2 weeks before they can go through this process of submitting their package to Farms, which is a nonprofit organization that facilitates the seasonal agricultural worker application. So if there are not any Canadian or permanent residents who are available to do the job, the employer can then proceed with this program. So the employer has to submit the LMIA application form and either the Caribbean or Mexico employment agreement to Farms, who then passes that on to Service Canada. The employer chooses which country they would like to request workers from, and if they are able to obtain a positive LMIA showing that a migrant worker will fill a labor shortage in Canada, then they are able to move forward, and it is the employer's responsibility to send the LMIA application form to Employment and Social Development Canada. Next, if the employer does receive a positive or a neutral LMIA, the employer can proceed to send a copy of the LMIA to the worker and the employment contract, which is signed by the employer, and then a worker in the source country must apply to Immigration Refugee Citizenship Canada for a work permit. So workers who are applying for a work permit for the SOP program, the agricultural stream, the high wage and the low wage streams, they are eligible for an employer specific worker permit. And what that essentially means is that it's also known as a closed work permit or a tied work permit, and it basically authorizes the worker to work for a specific employer on the work permit for a specific amount of time. So as you can see, even within the language, it is quite limited. So before a worker can apply for this work permit, they must provide, the employer has to provide the worker with a copy of the LMIA. And then the requirements for the employer-specific work permit, as you can see, are proof of identity, a copy of the positive LMIA letter, a copy of the contract, as well as completed application forms. And this process differs depending on the source country and where the applicant is coming from and where they're applying from. The application can be submitted either online or by mail, and they are all included on the website. So as you can already tell, there are some issues with the employer-specific worker permit. Workers are unable to circulate the labor market because they are tied to that specific employer. There is a power imbalance that results because of that, as we could see, and because essentially the employer has a lot of power. They are the ones who are providing living accommodations to the worker. They are also paying for the cost of the air and ground transportation of the worker, as well as any medical help that they may need, any kind of resources, any kind of support that they need. They are reliant on the employer. So as such, workers are often not able to voice their rights or stand up for themselves, especially because of fear of reprisal, because the employer also has the ability to repatriate them. And if a SOB worker loses their employment, they also lose their work status in Canada, which is very problematic because that is the single biggest thing that prevents workers from standing up for their rights and speaking out against the injustices that they and their colleagues face on a daily basis. So it creates structural inequality and vulnerability because the employment is relying on their employer for their stay in Canada. Next, we have the temporary resident visa, which is important to mention because it needs to be accompanied, it needs to be submitted at the same time as the employer work permit. And this is only for countries that workers are coming from, which are non-visa exempt. So countries such as Jamaica and Trinidad and Tobago, as well as a list of other countries, do require this to be submitted at the same time as the work permit. And it is also required if workers would like to have their spouse or their children visit. And it is very restrictive, as we will see in the requirements. So it can also be something that can be challenging to navigate, but it is very important for workers to submit. So as you can see, with regards to the requirement, it is for a temporary stay, and for the applicants who are applying, they have to be authorized to come to Canada and not intend to work or study unless they are authorized to do so, which they would be if they are in the SOP program or in the agriculture stream. No record of criminal activity, they cannot be a security risk, and also they have to provide additional documentation to establish their admissibility, which they can do so using the documentation that their employer provides. And again, they have to be in good health and complete a medical examination if they plan on staying for over 6 months, which individuals in these programs do. So there is an extensive medical examination that they must go through as well, and all of the details for that are listed on the Immigration Refugee Citizenship Canada website, as well as the application form. Next, we will be moving into the open work permit for vulnerable workers.
All right. Am I muted? I can't see my.
Nope, we can hear
Okay.
you.
I'll go through this quickly because I see we're running out of time. But this work permit is available for workers who currently hold an employer-specific work permit and who are experiencing abuse or at risk of experiencing abuse in the context of their employment in Canada. So abuse can exist in physical forms, sexual forms, psychological forms, and financial forms. So we've compiled a few examples of each kind of abuse. So in addition to the more obvious forms of physical abuse, like pushing or shoving or punching, this abuse may also be present if your employer provides you with a dirty bunkhouse and inadequate kitchen and washroom facilities, or if your employer is making you use chemicals without proper personal protection equipment, or if your employer isn't letting you visit the doctor. In terms of sexual abuse, it's generally any unwanted sexual activity in which you could not consent or you did not consent. And now psychological and financial are a little less obvious. So examples of psychological abuse could be, for example, if your employer is threatening to send you back to your home, or if your employer insults you, intimidates you, and calls you names, or even if you aren't directly experiencing abuse, but you see your coworkers being abused and feel that you're at risk as well. And for financial, your employer willfully and repeatedly doesn't pay you, or your employer takes away shifts, or your employer or the recruiter made you pay recruitment fees when you first came to Canada. I'll just skip this slide because we're running out of time. So just about the application itself, it is a free application and it has to be done online. You don't require a new LMIA, but you do require to have a valid work permit at the time of the application. You have to be in Canada to apply, so you can't apply from a port of entry or from your home country. And just to be careful about your browsing history if your employer does monitor the browsing and internet history. And in the application, you need to include some evidence. So at a minimum, you need to include a letter that describes the situation and the abuse that you're facing or at risk of facing. But you can also include additional evidence, and that could be a report from a doctor, or it can be a photo of an injury sustained from the abuse, or even email conversations or WhatsApp conversations that document the abuse. And so what to expect once you have applied. You may be contacted by an immigration officer to participate in an interview, but this is not required. It's at the discretion of the officer. And once you do apply, you should expect to receive a decision within 5 business days. So it's a pretty quick decision. And just be aware that the permit is temporary, so you should apply for a new work permit before the open work permit expires. And then lastly, just a few concerns that we have with this open work permit for vulnerable workers. So the worker does need to have a valid work permit to apply. Oh, my screen. So this precludes any workers who have a work permit that's expired or any undocumented workers in the country. It also has to be completed online, except for limited circumstances. So this may be difficult for workers who don't have access to internet or a computer. As well, the application is only in English or French. So this could be difficult if that's not your first language. As well, if the employer discovers the worker's application, the worker could be at risk for greater abuse. And the immigration officers do have a wide discretion to accept or reject the application. And again, it is a temporary permit. So the worker will likely have to reapply for another employer-specific permit, which will pose the same problems as it did before by tying them to the employer. And then we've just included some resources for more information with links attached if you're interested. And yeah, that's our presentation. Yeah, I've been looking for data on the open work permit for vulnerable workers, and I can't find how many have applied. And I also want to know how many have been accepted out of the amount that have applied, but I can't find any of that information.
Yeah, I mean, I think it's been a challenge to get these data for all of us. We should do information requests.
Yeah.
That's a great point. And I know we attended a presentation on this previously, and it was mentioned that it's very important for workers to make sure that they document everything as soon as they see certain signs of abuse or anything that they're even doubtful of. That might be something that they suspect that this is not okay and this should not be happening. They should start accumulating evidences, because the stronger your application is, the more likely it is that you will be able to obtain it.
I think that's a good point, though, that you made. And I think if the program could somehow guarantee a job once you have the open work permit, I think that would be a lot better, but I'm not sure if that will happen.
The work permit is attached to, for example, if you're applying to work as a shop worker or the agricultural stream, the work permit is required as part of that process for you to come to Canada to work as a migrant farm worker. For the temporary resident permit, it's basically if you're inadmissible to come to Canada under other circumstances, it's a way that you can temporarily extend your stay in Canada if your work permit expires. They can definitely try to apply for that. The only problem with that is also temporary, right? But and they cannot work or study as part of that as well. So that would be very restrictive.
Even for visa exempt, there are rules though, because what that means is they do not have to apply for the visa, but it still means they can only be here for like 6 months if they're a visitor, for example.
Also, the need has to be very compelling for them to enter or remain in Canada. And so if you don't have that work permit, then you definitely need a very compelling reason for you to still want to be staying in Canada. But just based off of just our research, it would make sense to apply for the work permit again, or like for the next year if you're able to secure employment through that means versus the temporary resident permit, because again, it is very temporary, it's very difficult to obtain, and you're not able to work or study for at least 6 months once you have obtained it. And you need a very compelling reason to want to enter or remain in Canada, and at any time you can be sent back. So it is a very precarious situation that you would be in. So I think just based off of that, it would make sense to reapply for that work permit, whether it's through either the SOP program or the agricultural stream, if you're able to come to Canada through that, then you have that, at least for that period, you have that secure employment that you can come to Canada and work for. I was just going to say quickly, so in order for generally the requirements for sponsorship, the child would have to be 18 years of age and would have to provide proof that they are able to support the individual that they are trying to sponsor. So just quickly, a child technically, they would need to reach the age of 18 and before they could go through the sponsorship route.
The only other option would be agency, humanitarian and compassionate.
I think that is true with the agri-food pilot. So that's a pathway to permanent residency. But there's that requirement. It has to be, I think it's 1 year or 2 years of consecutive work. And then also there's the education requirement and the language requirement. So that does kind of preclude a lot of the SOP workers. And I think that could be an area where, yeah, that's where reform needs to happen. I think to allow SOP workers, like if they've been doing years and years in Canada, that should definitely satisfy the requirement.
Yeah, I believe it's also for experienced non-seasonal workers, which again, precludes a lot of the migrant workers who's the way the program is designed it to be seasonal, especially for the SOP program. So that's why it precludes a lot of the SOP workers as well from that.